Hi, welcome to another session of our young researchers workshop on terrorism and belligerency. We focus on human enhancement and advanced technologies in terrorism and belligerency. This is the second session of the third day, which means this is basically the sixth lecture in the workshop. You can watch previous lectures on our YouTube channel, and if you watch it in a few days in the future, as I said in previous presentation, you can also see upcoming presentations, videos edited as well on our YouTube channel. The event is live streamed on Facebook, on the Minerva Center's Facebook page, and it is recorded for future purposes of editing and uploading into the YouTube channel. In this session, we have a great presentation, followed by an amazing respondent. I will now introduce the speaker and the respondent. The speaker will have between 20 to 30 minutes presentation, followed by 15 to 20 minutes of response. So here we go. Our presenter, Lea West, is an assistant professor of international affairs and associate director of the Norman Peterson School of International Affairs at Carleton University. Leah practices, studies, and publishes in the field of national security law. She completed her doctoral studies at the University of Toronto, Faculty of Law in 2020. Her research explored the application of criminal, constitutional, and international law to state conduct in cyberspace. She is also the national administrator of the Canadian national rounds of the Jessup International Law Moot Court and serves as counsel with Friedman Mansour law firm. Leah previously, law professor, right? Leah previously served as a counsel for with the Department of Justice at National Security Litigation and Advisory Group, where she appeared before the federal court in designated proceeding and the Security Intelligence Review Committee. And prior to attending law school, Leah served as in the Canadian Armed Forces for 10 years as an armored officer. She deployed to Afghanistan in 2010. Her presentation title is The Deployment of Facial Recognition Glasses in Armed Conflict, a case study of the relationship between privacy and precaution. Her respondent, which has even longer CV in this case, and I apologize in advance again, I'm going to give the short version. Brigadier General.
Because I'm older.
Because I'm older, well, because we have a 90-minute time limitation, and if I'm going to go for the entire thing, we're going to end at this pretty much. You see, I had that nice version. Ken Watkin served for 33 years in the Canadian Forces, including 4 years as Judge Advocate General. In 2002, he was appointed to the Order of Military Merit and has a lot of distinguished titles. He was responsible for providing operational law advice regarding Canada's military operation post 9/11 and worked as government counsel for various inquiries arising from the 1994 Rwandan genocide. After his retirement, he served briefly as a foreign observer to the Israeli Independent Commission investigating the 2010 Gaza blockade incident, the Turkey Commission, and is the author of Fighting at the Legal Boundaries Controlling the Use of Force in Contemporary Conflict, which, by the way, sits here on a daily basis, basically. And and another book he co-authored, The Law and War, A Concise Overview, which is where I read your bio. So, Ken, it's great to have you here as a respondent. Leah, I'm looking forward to hear your presentation, and the floor is yours.
Thank you. So I'm actually going to start by explaining why I wrote this paper. I served in Afghanistan, as I mentioned, or as Ido mentioned, as an operations officer in 2010 to 2011 during the U.S. surge in troops. And my job relied on intelligence collected through a variety of means, including the persistent use of drones, surveillance balloons, audio sensors, communication intercepts, and information collected directly from Afghans, either through human connections or the collection of biometrics. At that time, we were deploying HIDS machines widely to not just collect data about those who wanted to access coalition and Afghan military forces, but those who visited district centers, who made claims for damages from forces, and otherwise engaged with coalition forces. And I personally ran a successful operation to detain a prolific IED maker after we were able to identify them through fingerprints found on an IED. That same individual had previously been a human source for an agency, a different agency, and as a result had been given access to Kandahar airfield. Biometric collection was critical to the coalition strategy to gain identity dominance over the enemy. And in a long-standing counterinsurgency, where combatants would go for months without picking up a weapon and would interact openly with coalition forces as a typical civilian, identifying friend from foe was incredibly challenging, but necessary to the mission. And yet I can honestly say that I never once thought about the privacy rights of the local population. I was not a lawyer at the time, I was an ops, and I wanted as much information as possible so that we can make the best decisions possible. This was an era before facial recognition, before everyone carried a smartphone, before Facebook and WhatsApp had taken root in the region. But I can tell you that my position as a military operator today would be the same as it was then. Give me all the information I can get so that I have not only a tactical advantage, but that I know as much as possible and have as much knowledge possible about the people I'm aiming a drone at, or the local people in a village where I'm sending in an extraction team. And yet, as a lawyer, I know now that simply by virtue of living in a state of involved in an armed conflict or subject to occupation, the population does not lose protection of their universal human rights. The desire of a military commander for all of the information and their duty to obtain and leverage that information to satisfy their duties under the precautionary principle can't trump the privacy rights of an entire population. So with that in mind, I'm going to back up and first outline some of the facts and provide some definitions. Then I'll explain the IHL and IHRL, so International Humanitarian Law and International Human Rights Law principles I raise in my paper. And finally, I'll explain how I've proposed to balance or measure the balance between the human right to privacy and the humanitarian precautionary principle. And I'll conclude by identifying what I think is the weakness in my paper, because hopefully you'll have some helpful thoughts on how to counter that weakness and ask you for help on two issues. So first, some facts, definitions. What are biometrics and facial recognition technology? The term biometrics means a numerical representation of a biographic feature of an individual, such as their face, their fingerprint, or their voice. The really big first en masse collection of biometrics in an armed conflict was in Afghanistan, through the deployment of handheld interagency detection equipment, or a HIDS machine. They were used to collect, store, and upload biometric information collected from individuals in the field. They were rolled out in 2002 first to identify Taliban and Al-Qaeda prisoners in detention centers and collect data on them. But by 2011, the New York Times reported that an Afghan citizen would almost have to spend every minute in their home villages and never seek government services to avoid ever crossing paths with the biometric systems that we were deploying. Information collected by HIDS included facial photographs, iris scans, fingerprints, and also biographical information to go along with that information. This was used in part to establish identity dominance over enemy forces in the region, and that was a stated goal. And forces used this data and devices to identify insurgents, to verify the identity of locals and third country nationals seeking access to the bases or facilities, and link people to security events and criminal activity. All data compiled by US forces, at least, was stored indefinitely in what's known as the Automated Biometric Identification System, or ABIS, and was used largely in combination with watch lists to facilitate the detention and targeting of persons of interest who pose a threat to coalition forces and Afghan security. Eventually, in 2007, it was used beyond the United States. These systems were used widely by ISAF forces, And in 2011, it expanded, and that information was being collected to advance the causes of the Afghan government, specifically to conduct biometric enrollment for the population for the development of the country's digital identity cards. Since the initial deployment of HIDS in 2002, biometric programs have proven to be an effective offensive-defensive tool in armed conflicts. In 2017, a U.S. report found that the U.S. biometric program had been used by the Department of Defense to capture or kill 1,700 individuals and deny 92,000 people's access to military bases. Now, combining biometric data with facial recognition technology, I think, is the next evolution in this race for identity dominance over one's adversaries. Facial recognition is a biometric tool primarily used to automatically identify, verify, or authenticate a person's identity. In short, it analyzes key features and compares those features with other representations of an individual's face, often other photographs taken or posted online. When an individual is identified, their facial imagery is compared to a database that has other images, and also then compared to, for example, a list of known combatants or insurgents. In the future, facial recognition technology could also identify potential threats, so identify the unknowns, individuals contemplating criminal or dangerous behavior. So various studies suggest that artificial intelligence can recognize individuals registering suspicious behavior from their facial expressions, characteristics, or involuntary gestures, and even estimated heart rate. So that's rather than relying on known knowns, so fingerprints or iris scans, FRT mounted on facial recognition glasses or in helmets could give soldiers the ability to identify in real time, not just known, but previously unknown enemy combatants. Now, Chinese security officials are already using facial recognition glasses technology at border crossings, transit ways, and large security events. And essentially, security agents record video that is instantly cross-referenced against databases of images of already known criminals. Once identified, the individual's name can be searched against even further databases to quickly provide agents with a plethora of information about the target person. Similarly, Israel has incorporated facial recognition technology into its checkpoints and surveillance systems in the occupied territories, although the technology is actually not donned by soldiers, but it is at checkpoints. So because of the nature of the workshop, I focused on the use of facial recognition glasses by individual soldiers, but this technology could be incorporated into more persistent surveillance systems used on drones and military vehicles, etc. So turning now to the principles of law that are raised by the use of facial recognition technology, starting with IHL. From the perspective of international humanitarian law, facial recognition technology is actually quite promising. As this audience knows from our conversations this week, IHL applies only during an armed conflict and governs the conduct of all parties to that conflict, be they a state or non-state actor. A cardinal principle of IHL is that of distinction, and related to that is the precautionary principle. Now, the principle of distinction provides that all parties to an armed conflict must, at all times, distinguish between combatants and non-combatants. Combatants are members of the armed forces who are party to an armed conflict, except medical and religious personnel, and non-combatants are civilians, unless and for so long as they take direct participation in hostilities, persons who are hors de combat, medical and religious military personnel. Combatants may target and kill other combatants without that conduct constituting a war crime. Conversely, civilians may not be targeted, although they do not enjoy absolute protection against being killed. Moreover, military operations must be directed at military objectives, which include objects which by their nature, location, or purpose or use make an effective contribution to military action, or whose total or partial destruction, capture, or neutralization at the time offers a definite military advantage. So put simply, the principle of distinction partitions people and objects into two categories, combatants and non-combatants, and military and non-military objectives. Tied to the concept of distinction is the precautionary principle. IHL requires that in conduct of military operations, constant care be taken to spare civilian populations, civilians and civilian objects, And with respect to attacks, those who plan to decide upon attack shall do everything feasible, and that phrase is important, everything feasible, to verify that the objective to be attacked is neither civilian nor a civilian object. So part of what is included in this precautionary principle is the expectation of what is feasible and therefore obligated is the collection of intelligence, right? In order to be able to identify a civilian versus a combatant, a military objective versus a civilian objective, you need to gather information, right? There is an obligation, therefore, to collect intelligence. And therefore, it's easy to see how complying with the precautionary principle is often reliant on the collection, analysis, and sharing of information about potential targets, and how that is tied to intelligence gathering capabilities of the party to the conflict. So how much technological capability a state has, right, will impact its obligations under the precautionary principle. Now, that doesn't mean that all parties to a conflict are legally obligated to acquire, possess, and deploy the most sophisticated means of technology. The ICRC commentary on Additional Protocol 1 is specific about this. It says some belligerents might have information because they have advanced modern devices, while others simply may not. But those that have the capabilities are expected to deploy it in effective and reasonable means. In other words, belligerents will bear different legal burdens of care depending on the type of technology they have. That said, simply because a state has a specific intelligence capability, like facial recognition technology, for example, does not mean that a military commander would have to leverage that asset in every case. Interpreting what is meant by everything feasible requires a common sense and good faith approach that is taken from the ICRC commentaries to Additional Protocol 1. And so to do that, you have to consider a variety of factors. And this is important. The time needed to leverage the asset and process additional information from that asset, the extent to which it would clarify any existing uncertainty, competing demands for the asset, and crucially, any potential risks associated with its deployment. And those risks, I argue, could include privacy implications for the civilian population and the failure to comply with the state's obligations under human rights law. So the phrase, everything feasible, is highly contextual. Frederick Rosen wrote that due precaution may build on years of intelligence or on a sound split-second judgment. Although generally speaking, once a belligerent purchases equipment and supplies it to its forces in the field, it must be used if it's available, makes good military sense, and will minimize civilian impact. So under IHL, the precautionary principle says, in short, where a state has FRT, it should deploy it in an armed conflict to minimize the risk of non-combatants and comply with the precautionary principle and the obligation under distinction. So let's turn then to human rights law. Unlike IHL, international human rights law only governs the conduct of states in their relationships with individuals and groups that are subject to their jurisdiction. This is made up both of customary and treaty obligations, but human rights law, unlike IHL, applies at all times. Numerous international and regional human rights treaties protect the right to privacy. And I go through all of them mostly in my paper, but two of the biggies are Article 17 of the International Covenant of Civil and Political Rights, which says no one shall be subject to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honor or reputation. And Article 8 of the European Convention on Human Rights, which provides for that everyone has the right to respect for his private and family life, his home and correspondence. And there shall be no interference by a public authority with the exercise of the right, except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder and crime, for the protection of health and morals, or for the protection of the rights and freedoms of others. So it is quite caveated. That said, human rights instruments do permit states to derogate from certain obligations, including the right to privacy during an emergency that threatens the life of the nation, which would include an armed conflict. While the wording varies slightly between instruments, to actually formally derogate, each requires a state to notify other parties to that treaty that they are going to derogate and identify which provisions they're derogating from and why. That notification requirement significantly raises the political costs of derogation. It also acknowledges owing human rights to certain people, which we can get into. And scholars contend that it's for this reason that states rarely formally derogate from their human rights obligations. So while derogation is possible for privacy, it almost never happens. So the question is whether the use of facial recognition technology would engage, and I say engage, not infringe, engage the privacy protections afforded by human rights instruments, and the answer is almost certainly yes. We know from numerous human rights courts decisions that the persistent surveillance and collection, retention, and processing, sharing of data, personal data by a state, would trigger the application of human rights provisions. Moreover, a 2020 report of UN High Commissioner for Human Rights noted that routine audiovisual surveillance used in combination with facial recognition technology brings about significant risks for the enjoyment of human rights. And then citing the European Court of Human Rights, the report went on to note that a person's image constitutes one of the key attributes of his or her personality, as it reveals unique characteristics, distinguishing him or her from other persons. Therefore, recording, analyzing, retaining someone's facial image without their consent constitutes an interference with a person's right to privacy. But under each human right instrument, the protection of privacy, as I mentioned, it's caveat, it's not absolute. Intrusions into individuals' private life may be permitted, so long as they comply with certain criteria that can be summarized as the criteria of legality, necessity, proportionality, the need for adequate safeguards, and access to effective remedies. And then, what is necessary to comply with each of these principles is highly context-specific. Thus, what may be proportionate and necessary when, for example, there is a direct and immediate threat to life may not be so when a state's objective is less pressing or tangentially related to an intrusion. That's where a state complies with these principles, searches, surveillance, data collection, analysis, be it general or targeted, may be permissible under human rights law. There is one other key issue that must be addressed before moving on, and that's to the relationship of IHL and IHRL, and that's the question of the extraterritorial application of human rights instruments. Generally, under the words of a treaty, a state owes human rights obligations to those subject to their jurisdiction, which includes at a minimum those who fall within their state's sovereign territory. However, states may exercise jurisdiction extraterritorially, and increasingly have been found to owe certain rights to those who fall under their effective control, and that term is important. There are two recognized means of extending a state's human rights obligations abroad by way of effective control. So first, when a state exercises physical control over a foreign territory, which is known as the spatial or territorial model, and when a state exercises physical control over individuals in foreign territory, known as the personal model. So it is possible that a foreign state engaged in an armed conflict abroad may have human rights obligations to non-citizens abroad if that foreign state has effective control over either foreign territory or foreign persons. What does this mean? It means that the human right to privacy and those obligations on the state may apply during an armed conflict and could be triggered by the use of facial recognition technology, depending on the context, and potentially could violate a state's human rights obligations. So we have IHL pulling in favor of the use of facial recognition technology, as I talked about, under the precautionary principle. And we have IHRL pulling away, saying, not so fast. Use of facial recognition technology may violate your obligations under human rights instruments. So how do we resolve this tension? This is addressed in what I know is way too much detail in part 2 of my paper, which in a revision will focus less on this issue. Maybe it's a little pet project. In part 2, I explain how conflict between IHL and IHRL may be resolved. I explore various approaches that have been described and classified by Una Hathaway, and ultimately conclude that the principle of privacy and precaution are not in a true conflict, but exist in what she calls a relationship of interpretation. And as such, their relationship can be understood using what Hathaway describes as the complementary approach. Complementary is a weird word to me. Complementary approach provides that IHL can be used to inform our interpretation of a state's human rights obligations during hostilities in a way that allows us to avoid conflict between these two legal doctrines. This finds root in the ICJ's nuclear weapons advisory opinion, depending on how you read it, when the ICJ found that it was appropriate to use IHL to interpret what constituted an arbitrary deprivation of life under Article 6 of the ICCPR. And I'd say, as in that case, the language, structure, and purpose of the two norms we're dealing with make it relatively easy to resolve tension between IHL and IHRL rules. I believe this to be true of the tension between privacy and precaution. Why? Because as I've mentioned repeatedly, the right to privacy is certainly not absolute. As discussed, it's a right to be free from arbitrary and unlawful intrusions, and a state may take action that engages a person's right to privacy so long as they're prescribed by law, necessary, proportionate, there are adequate safeguards, and those actions will ultimately be consistent with human rights law. Moreover, what is necessary, proportionate, and adequate is highly contextual and fact-dependent. So as the ICJ did in the nuclear weapons advisory opinion, I say we can use IHL to help us interpret what is necessary and proportionate and adequate in an armed conflict, be it an IAC or a NIAC or a prolonged occupation. So as we know, the precautionary principle under IHL stipulates that military commanders must do everything feasible to verify that attacked objectives are not civilian and take all feasible precautions when selecting means and methods of attack to minimize civilian casualties. These rules obligate states to take positive steps to collect intelligence and conduct surveillance so that they can efficiently and effectively distinguish friend from foe. Therefore, the need to comply with the Geneva Conventions must influence our interpretation of whether using a surveillance technique or a program like facial recognition technology is necessary and proportionate under human rights law during an armed conflict. Recall, however, states with facial recognition technology capabilities are also not obligated in every instance to use that technology to comply with Article 57 of Additional Protocol 1. If there are alternative means of safely and efficiently verifying the nature of a target and satisfying that precautionary principle while having less of an impact on civilians, a state with facial recognition technology need not use it or need not use it indiscriminately, for example, in every instance. Meaning, where possible, the right to privacy should also influence the choice of surveillance programs and techniques employed by military commanders. So ultimately, this relationship is highly contextual, and where the balance lies between privacy and the need to use all feasible means to ensure a target is who you think it is will depend on the context a commander finds themselves in. So how then do they figure out what to do? I propose that this balance or this spectrum shifts in accordance to two key factors: the level of effective control a force has over a territory or a population, and the level and threat of ongoing violence. Well, why? First, the degree of control increases. As the degree of control increases and the level of threat and violence decreases, three things change. First, and I know even raising this case will raise eyebrows, but as the European Court of Human Rights recently found in Georgia and Russia too, the context of chaos is an important factor for establishing that a state is exercising effective control over a territory or persons, such that they can be said to even be exercising jurisdiction. Now, this has always been a necessary prerequisite, the exercise of jurisdiction and effective control, to finding that a state owes human rights obligations. But in Georgia and Russia, the court also makes kind of clear, it wasn't a unanimous decision, that the level of effective control over persons during an armed conflict will determine what human rights obligations are engaged. Second, these factors, effective control and threat or use of violence, are crucial for determining what qualifies as necessary, reasonable, and proportionate intrusions of privacy in order to maintain security. And third, those two factors impact the tools, means, and methods available to satisfy the precautionary principle. So for example, in a stable, low threat environment, having a conversation with someone may be a suitable way of identifying who they are and if they pose a threat. But in a hot zone where fighting is taking place from block to block, combatants intermix with civilians, the use of facial recognition technology and the data that makes it powerful may be the most effective way to limit collateral casualties. So ultimately, these two factors push the privacy obligations of a state in an armed conflict along a spectrum that shift with the context of chaos, if you want to follow the ECHR, or the context of the conflict, from least protective during the height of a violent conflict to most protective, for example, in a prolonged and stable occupation. I'll just wrap up by saying the weakness of my approach, I believe, is that it's going to be challenged to operationalize. And setting parameters or thresholds based on these factors would also be challenging to operationalize. And I fear that for that reason, it might be discounted by one side or the other, depending if the reader identifies with the military operational perspective or the human rights protective perspective. That said, I do think that choosing either or approach is just wrong in law and opens states up to findings of wrongdoing by human rights bodies. The two questions I have for you that I would like help with is, first, I'm looking to shore up my argument that I have identified the correct factors, being effective control and threat of violence. I'd be interested if people have any additional factors they believe I should include, or if they have any ideas of where I could look to support those contextual factors. And second, I'm wondering if you think it's necessary to be more prescriptive in the third part of my paper and identify the actual type of privacy protective mechanisms that should be scaled up to favor, if the balance favors privacy, or if given how contextually dependent that would be, it's okay to just kind of leave it general. So that's it. Thank you very much.
Thanks a lot, Leah. And now, Ken, as a respondent, the floor is yours.
Thanks, Ihl. You hear me okay?
Yep.
Good. Okay, so no, at first when you were saying my CV, I was just saying that mine's longer because I'm older. So anyways, there you go. Yeah, Leah, I really enjoyed your paper. And when I read it, I saw the subject matter and I thought, okay, all these boxes need to be ticked, came across my mind, and I went through the paper and they were all ticked as we went through. And the only one I was concerned about was Georgia versus Russia 2, and it came up at the end. So that basically got through them all. So my comments are more focused on some of the things which you've addressed, like at the end, on that, maybe some ways of dealing with it, but also maybe some more nuance and a bit of not pushback, but a different perspective, I think, on the scope of the human rights during armed conflict, the jurisdictional questions. But I'm going to cover, I think, sort of four main areas. One's the technical capability targeting, facial recognition and privacy, a bit from a domestic law perspective, and then the international law perspective, and then finally the scope and reach of international human rights law. On the technical side, you've identified it's largely been used in this sort of vetting type process, although it's also, as you mentioned, for getting your IED cell member there. It's also used for prosecutions in terms of criminal live accountability. But a good book I found is the one by a fellow named William C. Burrow, who talks about biometrics in support of military operations. It was written in 2017. So one of the challenges with this area is the technology is changing so fast. The literature gets out of date. And it's the same issue as artificial intelligence and as well. And one of the things I thought you might look at is expanding beyond the idea of the soldier's glasses, which may not be there yet, but are either are or closely coming. The U.S. is doing a lot of work on virtual reality glasses, as you may know. But you mentioned drones as well. And one of the things I've sort of started to look at is they're now working potentially using being able a kilometer off to be able to use facial recognition for drones, which is a tremendous capability. And it's alleged that in November 2020, at least the Iranian government alleges that facial recognition was used for the killing of the nuclear scientist in Iran as part of that machine gun that was set up and dealt with from a distance. So that's something you may want to look at in terms of turning it more to a targeting focus. I might add, though, that one of the advantages would be, let's say, the quite tragic targeting of the humanitarian worker at the end of the NEO in Kabul. What if they'd had facial recognition? And we're able to employ that. As you know, it is time sensitive. There's never enough intelligence. There's never enough time. Your decisions are often only as good as the information you have input. Ultimately, a decision has to be made. The challenge, of course, is, I think you identified in your paper, is issues of accuracy, false positive, false negatives, also racially biased issues, which you might want to touch on as well. But if it's a 93% accuracy, we're all happy with that with vaccines in terms of keeping us alive. And just wonder, in a targeting perspective, what the percentage would be that's acceptable or not acceptable in terms of accuracy. And there's always the question of the consequences of the error. One thing with respect to privacy is, and you touch on that some countries are already using it, like China and Israel, which are ones we can pop up that sort of have issues. If you talk about the occupied territories, or you talk about China, it's used facial recognition. I mean, it has a much broader connotation just in everyday society, as you know, and it's one of the issues you may want to address because it's here and it's likely here to stay. I'm a big fan of the British crime shows, and while that always seems at the right point, the CCTV doesn't have the perpetrator on the screen. It seems to be a big part of some people's lives in the world, and facial recognition increasingly is there. But it's also, even in our own societies, it's a relative term. So if you think of privacy, even from a Canadian perspective, our courts seem to accept you have a lot less privacy rights external to the country trying to get in than you do inside the country, which raises questions about how universal and how international privacy rights are. So there's that sort of issue. I might add as well that the Liberals, our governing party and our minority government, use facial recognition to vet the electors for their candidates. It's really part of society. So even in various domestic contexts, so it shouldn't be surprising that even on international operations, it's you find that it's there, and so that's something it's quite often talked about as an absolute. I find by many human rights advocates, and I think oversold sometimes in terms of the right to privacy. So even though our privacy commissioner came out with the allegations that our National Police Force was using, as you know, Clearview, the National Police Force pushed back and said, no, we think we're using it fine, right? So it isn't resolved in our societies, is I guess the point I would make. On international law perspective, privacy, and I think the question is one of scope and reach, but even from an IHL perspective, I don't think there's been enough, and quite often this is the approach that people jump to the human rights treaties quite often without doing a little, dig down into IHL as to what might be the basis for arguing there's a privacy perspective. Article 46 of the Hague Regulations, family honor, lives of persons, private property. GC4 is another example. Article 27 talks about the rights of the person, and AP1 Article 75 talks about respecting persons' honor, corrections, family honor. I mean, very similar to some of the wording mentioned in the human rights treaties. And of course, AP 75 was almost a direct lift from the ICCPR on much of this. So so was it purposely left out? It wasn't, those types of questions. I think there's some scope to say it's even part of IHL, particularly in an occupation scenario. Where I find a lot of this discussion starts to be problematic is in the world of absolutes. So claims by states as lex specialis for IHL certainly were initially presented as extreme absolutes, as you note, displaces human rights law. And the US and Israel are the countries that are most often brought up to this. But the US has become more nuanced, certainly. I can't find much about the Israeli approach, but the US approach has become far more nuanced, particularly with respect to the issue of detainees. It's certainly not completely abandon it, but I can certainly provide you some sites that would highlight some of that change. I might add as well, the Canadian position is that it's lex specialis, IHL. So those aren't the only countries. And one of the challenges in this area is some countries are vocal about it and some simply aren't. So it's hard sometimes to define where their reference is. I think if you mention not only the nuclear weapons case, but also mention the Wall case, where you'll find, that reference to some cases it's IHL, some cases it's purely human rights law, and some cases it's both, will provide some more nuance in terms of resolving them. My favorite quote from our own federal court in the detainee litigation was that they found that the Human Rights Committee commentaries were groups with advocacy responsibilities. What they provided was not necessarily the law. And so that's another challenge in this world when you try to resolve these two bodies of law, is that it's quite often it's highly theoretical. It's not bounded necessarily in positive law, and it's quite often opinion and overstated too broadly. And I find quite often human rights advocates are equally guilty of this, as are some advocates for the pure lex specialis IHL rules, right? So when I first looked at the Dayton Peace Accord and I read one of the annexes that set out all the international treaties that were going to apply to, Bosnia and the Balkans after at the end of the 1990s, I was astounded, and I thought many of the countries that are advocating this haven't signed on to these treaties or themselves, right? And so there tends to be this tendency of saying, well, all this international law applies with you without a sort of serious discussion about whether it would work in the context, as you've mentioned, the contextual approach, and whether they actually apply in law and fact, not just in theory. Canada as well, for example, it takes the view that the ICCPR is highly territorial, and so would not necessarily rush to embrace this sort of broad application on military operations overseas. And the detainee litigation certainly said the domestic charter isn't the law that applies overseas. So, there's countries take different views than human rights advocates, and the two need to be resolved. You've mentioned about effective control, state and state agent authority, which are this personal thing, which are obviously the two main approaches. I would encourage a deeper dive into Al-Skaini, Hassan, and the Jaloud cases for occupation, because ultimately they didn't apply the spatial control test. They sort of went more the personal, right? So either persons detained or stopped at a checkpoint, the human rights law, the European human rights law would apply. And so it's very frustrating for many human rights advocates, but it wasn't a broad acceptance that even in position at times of sort of occupation, that there's this broad application of human rights law. And I find the Georgia case particularly interesting because it not only was a return to Bankovich, in fact, it was in many ways far more stark than Bankovich, because it effectively said amongst member states, this period of chaos, the European Convention on Human Rights does not apply. So it wasn't just an external, it was internally within the Union. And so I think this is quite a stark, challenging approach for advocates of extraterritorial application. And so that sort of is one of the challenges. What doesn't happen in the international community largely is reliance on customary international law. I mean, for the ICCPR, there are 20-some plus countries that have never signed on to it. So what human rights law applies to them? Outside I forget how many members are signed on to the European Court of Human Rights jurisdiction is mid-20s, some sort. What about the rest of the world? These sort of broad sort of discussions of the application of law are not necessarily reflective of what happens sort of everywhere. And I think that's sort of an area that has to be addressed. I think one of the most interesting things you get to the point was at the end is the very question you raised. It's this. Una Hathaway's approach is one of the models, obviously, or it's a good theoretical model upon which to address it. But in many respects, it, like a number of analysis, leads to almost a sliding scale of approach, right? And so, as you know, the complexity of a counterinsurgency in particular, issues of control to me make sense. Issues of threat make sense. And if I was looking at a case, I would look at the targeted killing case in 2006 in Israel, which those are the very issues that the High Court of Justice looked at in terms of the application of human rights principles within IHL. The controversy being whether they got it right in terms of the application of those principles of capture rather than kill. But those are where those principles are most obviously applied. The challenge is, how do you operationalize this approach? So, and that leans itself to saying, no, we're going to apply IHL, or we're going to apply something else, this sort of binary approach. And from an ROE perspective, it's risen in the same way. So if you look at the Colombia example, one ROE for conflict, one ROE for human rights, law enforcement. But the question is, what if you were dealing with civilians in a context of applying the armed conflict ROE, right? It always raises its head. What I would, one of the approaches that I've sort of looked at is more of a functional question. What is it you're asking people to do? And so for a use of force perspective, what's come to my mind most obviously is, if what you're being asked to do is a law enforcement function, that more readily embraces a human rights type perspective, as opposed to if you're doing an armed conflict fighting against the enemy perspective. So to put that into your context in terms of collection of biometrics in Afghanistan, if you're trying to create a digital ID, that strikes me as being in the law enforcement normal governance type perspective. If it's questions of whether you're going to kill someone who is going to attack you or the civilians as a suicide bomber, that puts you more into the question of IHL in terms of breaking out. So it's functional as opposed to otherwise. And if a government takes a policy perspective of saying we will only apply a law enforcement approach, as the UK did with Northern Ireland, then you would apply the privacy human rights law approach as a way of trying to resolve it. And it's one area where I've written about, and interestingly enough, Monica Hakimi has wrote an article that suggested more along the lines of this sliding scale approach. Very, very well done article. And Mitt Reagan recently did an analysis of both my approach and her approach to look at ways of dealing with the issue. And so that's in the National Journal of Security Law and Policy from a couple of years ago. So that might be one approach where you can see someone who's sort of looked at the two approaches and sort of has come up with where he leans in terms of his result. This technology is here to stay. It's like artificial intelligence. If indeed it's tied to artificial intelligence, and it raises many of the same issues, and that may be something you want to address as well in the beginning in a line or two. The question is the horse completely out of the barn, or is there some way to corral this and manage it at the end of the day? And the nightmare scenario is a drone which is completely autonomous that uses facial recognition targeting individuals, right? Is the one scenario, and one of the challenges in terms of applying targeting laws, it's different conceptually when you think of a drone strike where everyone has a perspective where you have all sorts of time to look at this, and there's a hierarchy, and it's commander responsibility, and all sorts of factors can be brought into play, which is much different than the tank commander who has to make a decision on whether they're going to use force or not, and it applies to every member. And I guess that's another issue of how much that changes your assessment of what privacy factors there are, and ties into this time component which you mentioned. So that's my perspective, and I'm happy to provide sort of more comments offline if that'll help, more detailed comments as well. So good paper.
Thank you so much. That's incredibly helpful, I think, especially this concept of functional, because when I was first conceiving of this paper, I had like this, I drew on this diagram where it was IHL was thicker on this side and privacy was thicker on this side, and they kind of merged in the middle. And I had written, you know, IAC, NIAC, occupation, counterinsurgency policing, you know, and how it kind of went across that spectrum. And to me, it made sense, but I didn't really know how to verbalize that. So the question of what are you asking people to do is so helpful in thinking about that. So thank you. The one thing I will say is that I do think, and I don't think I emphasized it enough, but I definitely should because you raised it, was, I mean, there is some development of an acceptance of a universal or a customary right to privacy that's been developed in human rights law. So I think I should emphasize that so that I am capturing all participants, state participants to armed conflict.
The only other thing I meant to mention was, just you mentioned that came to mind, was it's also the issue of how this applies in conventional large-scale conflict versus a counterinsurgency, counterterrorism scenario, and whether it lends itself to greater application in the latter type of operation than it does in the conventional side. But, yeah.
For sure. Thank you.
Okay, so right now we're going to open the floor question. And before we go to Agatha, for the first time in this workshop, I actually want to exploit my position as the moderator and take the floor first. With your permission, Agatha. First of all, very, very interesting paper. I have to say I'm writing on the right to life of combatants from different aspects, and I see a lot of similarities, in especially when we talk about the application, extraterritorial application of IHRL, and the interplay between IHL and IHRL. And then in a lot of your writing, actually get some confirmation to what I've been thinking about these issues, and it's great to see that. Basically. I do have some question and comments, not question and comment, but questions and comments. Let's start with the notion of derogation. To the extent that there is such notion, and we know that there is in the letter of the law, but I think what we've seen the last couple of years, especially in the context of COVID, is that states have violated human rights by talking about what you can do and what you cannot do, preventing their entrance to the state and preventing the freedom of movement, confinement, and all the lockdowns, everything. There were a lot of IHRL violations there, or alleged violation, let's put it like that. And there were actually statistics, and there are websites that actually followed which states actually derogated in accordance to the ICCPR and in accordance to European Convention of Human Rights, and most states didn't derogate. It's clear that there was state of emergency. There were extreme conditions at the time, and no derogation. So I'm not necessarily saying that this is the way the paper should go to, because that would be a complete different discussion, but we should take into account the fact that perhaps state practice starts to show us that derogation is within context rather than it is with actual declaration when the situation is that clear. That's a general thought. I'm not sure how I take it, but the last couple of years, the COVID situation has showed us something about the entire notion of derogations, and we need to address that in a certain way. With regard to the extraterritorial application of IHRL, maybe I missed it a little bit, but I didn't see any reference to the notion of the functional approach of the application of the IHRL, extraterritorial application of IHRL, which has been discussed both in the European Court of Human Rights and the Human Rights Committee. Human Rights Committee in General Comment 31, and in the European Court of Human Rights, we see it in several cases, but in Ascani, we actually see it, and you refer to Ascani in the personal approach, but there. And actually, even within Georgia versus Russia too, there is a dissenting opinion of Judge Albuquerque, which says, who rejects the notion of going back to Bank of Age, or as Ken said, even going further than Bank of Age, and said that functional approach is still relevant to the situation. And at the same point, we have the Human Rights Committee in General Comment 36 about the right to life, again, reiterates the notion of the functional approach. And even recently in the Italy communication about the people on the sea trying to go, and there was an issue with Malta and Italy, people who should save them. Again, it's in the context of the right to life, and I'm gonna get that connection again right now. But there is that question of the functional approach in the extraterritorial application of IHRL, which might be useful for you, by the way. Now, when I started reading your entire IHRL discussion, I was thinking, where's the clash? In order to have that lex specialis discussion, especially if you go to Milanovic and Hathaway and all the approaches, they're looking for the clash. If there is no clash, unless you go pure lex specialis, we have no problem. IHRL applies. And I was thinking, where is the clash? And then you said, well, precautions, everything feasible might be a precaution, because everything feasible might lead to a breach of privacy. And then I got thinking, well, if we don't do that breach of privacy, we might end up with a deprivation of life of that person. And this is where I got super excited, because this is where I swim right now. I swim in the right to life. So there is a clash between the right to privacy in a way, you can actually, if you take it to the extreme, and the right to life. And it's not a direct clash, I would say that. It's not a direct clash, but the more we do in order to protect the privacy, we might end up with a bigger collateral damage. And this is where it became, I basically started to spiral around myself. And this is where I would love to see some reference in the article talking about the fact that there are outcomes outside of the question of privacy. And and the last question is again within the extraterritorial application, that I think most of the gathering of information is done in cyber methods, right? Most of them. I'm not saying all of them. I'm saying a lot of them. Let's say it could be done. Let's pray. A lot of it could be done through cyber, which means there is no necessarily territorial breach of IHRL, and then we go into the question of whether or not going into a computer placed in someone's house to gather information about that person constitute breach of privacy. Now, you're talking about using glasses and actually getting the person. I would say, okay, I can use the cyber ability to get into your computer camera and actually get facial recognition of you from very close range. And that would be like the 100% proof that this is the person I'm looking for. So this is definitely undeveloped, but there is a question there of how would you consider the entire discussion of effective control with regard to breaching through cyber and not
that's
breaching.
My PhD dissertation. I wrote about that already. Yeah, so my SJD dissertation was on the extraterritorial application of the Canadian Charter, specifically in the context of state cyber operations. And so in order to do that, I had to understand the extraterritorial application of human rights obligations as it applied in cyberspace, and then Canadian domestic human rights. So I've done a lot of that thought already. And I specifically talked about biometrics, and I avoided the conversation about the broader data aggregation and collection associated with facial recognition technology, simply to avoid all of the other stuff that comes with it. Because then you also have to think about data protection and et cetera, which requires different different legal requirements, et cetera. You start to get into data protection regimes. And I was trying to avoid all of that and be much more narrow in the context of this technology. But I don't disagree with you. My position is that even if and the position of European Court of Human Rights is that states still owe privacy or human rights obligations to people outside of their state when they're acting from within their state. Canadian Supreme Court disagrees with me, but I think they're exceptionally wrong, and I've written a lot about it. So I totally agree with you that those issues are interesting. I've spent years writing about them, but I was specifically trying to narrow in and avoid those issues because I think that they're 300 pages of a dissertation worth of writing. I definitely think I will include the functional approach. I tend not to when I talk about it, simply because it has only been found in certain narrow instances. And I tend to be like, these ones are more accepted. They're beyond just Al-Skinny and the Human Rights Commission. But I will definitely include it because I do think it could lead some support to this functional approach that General Watkins raised. And I think the derogation issue is also really, really interesting. I'll have to think about how to include it. It may just be worth noting that there may be a way of recognizing derogation outside of this formal means, and that needs to be considered. I would argue that we then have to think about whether the context of an armed conflict is one of those contexts that you raise where it's obvious, right? Oh, it's clear we're in an armed conflict, and I think that might be dangerous. To go that route and say, well, as soon as there's an armed conflict, just like as soon as there's a state of emergency, it's obvious that we're going to derogate.
When you have the chaos, which the European Court of Human Rights doesn't want, it would be.
So, but I think it's definitely something I think that's fascinating. I didn't know about those websites tracking that, so I'll definitely go and research that. So thank you.
So we move with Agatha, please.
Thank you. I think that your paper was really fascinating, and I absolutely love it. I really enjoy always such legal analysis, and I was trying to listen very carefully to what was said already, and I hope I am not repetitive in what I'm going to ask, but I was wondering whether you tried to establish whether the right to privacy is not a customary law that is applicable also in the time of armed conflict. I am aware that, first of all, you would have to establish whether the right to privacy is a customary law, and what is the extent of the right to privacy, whether it would be applicable also in terms of the armed conflict, international, non-international. And yeah, that's my question. Thank you.
There are some, and I reference a piece by Asad Lubin a lot because he kind of wrote the most kind of holistic paper on this concept of right to privacy in armed conflict. And he references others, and I believe the Human Rights Committee, who does suggest that the right to privacy is customary international law because it is so well-founded, not only in international the UN Declaration of Human Rights, various human rights conventions, but also domestically. It is almost in every domestic human rights treaty or convention or whatever you want to call it. So there are certainly those who advocate for the fact that, and I think the argument is strong, that the right to privacy is now protected under customary international law. Whether or not that changes between an IAC and IAC, et cetera, like obviously in an IAC, if you're dealing with the state, you get more into the questions of, is it derogating from its obligations to its own citizens versus an IAC, where you're talking about that extraterritorial application issues. And I think that's the more nuanced question rather than whether the law is custom, because you still have to get down to the, does it apply, even whether it's in custom or treaty. So you establish both, great, right? Because then we can say everybody has this obligation, that's a state, but then you have to think, does it apply in this context? And I think that's trickier as we're talking about extraterritorial application, but I don't think it depends on whether it's custom or treaty-based. That would be my sense.
Thank you.
Thanks, Agatha.
João?
So I mean, the presentation goes into a lot of legal matters that are definitely beyond me, and Kenneth's comments helped me a lot to understand better what's at stake, by the way, and thank you for that. But if I may, forgetting the laws for just a bit, in concrete terms, what is the case for privacy here? Let's say, take an innocent civilian in a war zone. We're deciding if we ought to collect his biometrics. If we do, we will reduce the odds that he will be wrongly killed. Or at least if we do of everyone in the area, their odds of being wrongly killed will be reduced. But we would violate his right to privacy. But the right to privacy, even in philosophy at least, the many philosophers who defend it will concede it's not a very popular opinion that it is a fundamental right. And even those who believe it is a fundamental right would say it would be overridden by the right not to be killed or the right to life. So if we are balancing killing the innocent versus violating the privacy, what is the case for privacy?
That's a great point. I think the only way I can answer that is if looking at the context of the war in Afghanistan, where the collection of the information was first used for that purpose, and then subsequently used not just to not kill innocent civilians, but there is the mission creep. Once you have the information, it becomes difficult to control how it's used, and it no longer becomes this tension between right to life and privacy. It becomes a greater tension in ultimately this privacy, anonymity, the ability to live one's life without intrusion from the state. And so I think that you raise an incredibly important point, and this is kind of what I'm thinking about doing in my third section that I didn't hear, was explaining more concretely what I mean about protecting the right to privacy in this context. And it's more about secondary use, secondary application, how much data can be collected, how much it can't, to avoid that subsequent use of that data, that information, when it's not balanced against the right to life, because we constantly see that mission creep when we have data collection. And I think you raising this question, raising the counterbalance between the protected right to life, and it was also raised in another workshop I've done, really does make me think that I need to spend more time talking about the mission creep implications for privacy when it's not just about that balance. Because there are lots of military applications of collecting data that aren't grounded in an IHL obligation, right? So I think that needs to be addressed. And I think the way you put it is very stark and definitely reinforces that. So thank you.
So I have a follow-up question. It relates to everything. I think it was kind of said that this is here to stay, the technology. And every time we're dealing with a cyber-related development, there is always the question of, is it cyber unique? Is it technology unique? Or do we have the right tools right now? Or do we need a new set of tools to be able to manage that? And I wonder, in the long run, do you think that the discussion of the right to privacy in that context would lead to a necessity of new set of laws and regulations? or whether they be through, I don't think they would be through IHL, let's be realistic. But would they be through IHRL? Or they think that the existing mechanism, laws, and relation is sufficient?
Well, I definitely think we're moving to a situation where state forces, we're just talking about states here, state forces are going to have to come up with policies with respect to data collection when it comes to armed conflict. Like, I don't know how you get away from that, because it is becoming such an important tool, data collection writ large, whether you're talking about data analysis of terrain or of individual populations to identify groups that are more likely to be sympathetic. Like, there's so many data analytic capabilities and facial recognition capabilities and AI generated capabilities that are reliant on data, personal data, where I think states are actually going to have to come up with policies. It cannot be that we just don't think about these things because we're deploying them in an armed conflict. And I think especially because that data doesn't disappear at the end of armed conflict. Once we get out of the context of chaos, the data continues to exist. You continue to have control over it. And you're no longer in a situation where you can rely on, if you want to, lex specialis. So I think states are absolutely going to have to come up with policies. I think it'll start more like ROEs, where it is state driven. And maybe over time, we'll develop some sort of norms around what is required. But I do think it would be IHRL at that point. But I don't think states can ignore this, because at the end of the conflict, or whenever you're in a situation where it's clear that there's functional or because of occupation or whatnot, the human rights law applies generally, you're left holding the bag with all of this data, and you're going to need rules and policies to deal with it. And they should not be, this is kind of the whole point of my paper, you shouldn't be doing this on the fly. You shouldn't be thinking about this after the fact, because when you don't, you get biometric data in the hands of the Taliban, So I think that's ultimately my bigger picture point of this paper.
Yeah, because okay, I had a follow-up. I think Kaya has a question, so let Kaya.
Just a quick comment, because actually when you were saying, Leah, about there was this comment, you said that you were especially focused on biometrics, not to go into discussion on data protection, and then I was like, biometrics is data that is protected, at least by GDPR, and I just opened the GDPR, and maybe you can just include some, there is this 112 motif of the preamble saying exactly that states that there is no legal vacuum, at least in the European Union states, when it comes to this kind of biometrics data, yeah? And from what you are saying, probably there is no policy, or they are not available publicly to public opinion, the policy on the transfer of that data. I saw also that ICRC recently had some kind of discussion on personal data. And I would like to ask if you could comment just on that, if you have checked the GDPR implications for legal missions, although it's...
I haven't, because I was trying to stay away from data protection, only because I think data protection raises all these other questions about all these other things you need to think about, and I wasn't prepared to go into
privacy at the same time is data protection, and biometrics is personal data, right? Or it's not? I just
biometrics is. I mean, the collection, once you've collected it, it is absolutely personal information, no doubt about it. I was trying to focus on, because under human rights law, there are the privacy rules, right? And then hived off from that, now there is the development of data protection rules, and they're not the same. And what I was trying to avoid is trying to say, and these are the data protection things you also need to think about military commanders when you're doing facial recognition technology. Well, I think that is something that does need to be considered. It adds another layer of I think, reason for military is to say, this is ridiculous. Like, I'm not complying with the GDPR in an armed conflict, right?
When you think about why GDPR was implemented, it was not just to regulate Facebook, etc. It was also somehow to protect our privacy. And there are
again, though, it doesn't apply.
The rules that you are talking about
and that kind of thing. There are, like, at GDPR, there are carve-outs as well in the GDPR for national security. So I think that's important as well. And again, the GDPR doesn't cover everyone, right? it's regional. So I take your point. I don't disagree with you that data protection is an important factor here, but it is a whole other area of consideration if you're actually looking at human rights. Data privacy or data protection and privacy are not universal, right? They require different things. And so I was trying to play on the tension of privacy and precaution, because privacy isn't just data. It's all these other things. It could literally be just facial recognition glasses deciding whether or not somebody's a bad person or not, and like recording that information, which...
Okay, so just one follow-up question. When you were in Afghanistan, the processors, you said there was this technology was not available, but we discussed on the first session this case of drones and Ramstein base, and I can imagine that this data is also transferred through European Union when it's somehow performed between Americas and Asia, right? So I would go with the fact that the states would be responsible for that, and then you can draw on some principles. Like you said, data was used for targeting, that's okay, but when we collect it and process it for other reasons, then it's somehow against the minimization or I don't know.
No, I think my point there is that you're not fighting up against the right to life, right? This tension between privacy and precaution goes away when you start to use it in different contexts.
Right.
And that's my concern, is about once you had that information, there's no longer this tension that justifies minimizing privacy rights.
It's different objective.
Yeah.
Right. Thanks.
And I don't necessarily agree with the Ramstein case at all. So and it is a domestic court in Germany that bases everything based on consent of the German state in that case, which wasn't even required. So I question how applicable it is in broader contexts. I take your point. Like I don't think that data protection is not an issue that needs to be considered in an armed conflict. Absolutely do. It just wasn't in the scope of my paper.
Okay, thanks.
Okay, so now I want to go back to my previous follow-up. I want to play devil's advocate for a while. And I want to ask, what would be my incentive to actually regulate the use of that information that I collect? My argument would be, during the armed conflict, I use it, as we said, we talked about, to minimize harm and to be more accurate, to go with every principle of IHL. And later on, I would use it for security needs, to recruit double agents, to recruit people to work in my favor, to gather better information, which later on would lead to me targeting the right persons, even capturing the right persons, in order to avoid unnecessary suffering from other persons. Clearly, the person being double recruited won't be happy about it, but in the big run, as the state, I would actually benefit from that. And so what would be my incentive as a state to actually agree to regulate that, which eventually that would be the key point in finding a solution on international law?
So I think because what is proportionate and necessary will change over the context, right? So what information you've been allowed to collect in the context of chaos, right? And what is necessary and what tools you're allowed to use, right? And you collect that information doesn't necessarily translate to what's necessary and reasonable and proportionate in the other context. I'm not saying that it wouldn't, but it's unlikely that just massive surveillance of the entire population, ingestion of their data and analysis of that would qualify as reasonable and proportionate down the road, if you haven't taken other measures to comply.
So I have to ask, can you differentiate between, in that case, between, let's say, the US has left Afghanistan and Israel and Hamas, which we know it's a recurring and it's just a matter of time until I will actually need that information back again?
Yeah. Because I think you're moving along towards a more law enforcement counterinsurgency operation on the one end, rather than you have no idea who the enemy is, where they are, and where they're coming from versus the local population. In a long-term occupation, you have many other factors and facets of information available collection. It's not about just the level of risk, right? And the fact that there's a future risk known versus the immediate threat and there's no control. I think that's why I have these two factors, because it changes what is reasonable and proportionate. And even just because you are able to collect something in one context doesn't mean you get to use that in another if what you've obtained would be found to be unreasonable and disproportionate to the threat in the other context. And so I think that's why it behooves military commanders to think about the fact that we're going to want to use this information for other things. We need to figure out how to manage that change in what is reasonable and proportionate as we move down that spectrum. And it doesn't necessarily mean that you have a bunch of secondary use protocols in place during armed conflict, but I do think you need to have the capabilities built in to then employ those secondary measures once you move out of that, intensity of conflict phase, which requires thinking about things when you're building your processes, when you're building your data collection capabilities, access controls, that kind of thing, because it's hard to do after the fact.
Ken?
I think one of in this discussion has sort of triggered some stuff in my mind, but one of the questions is, what's the reasonable expectation of privacy? And I think that might, it's back to what are you using this technology for in a way? And, one of the things that comes to mind is it's almost a universal thing, and it isn't quite often thought that way, but searches of private homes have been particularly controversial in Iraq and Afghanistan. But it's largely put in the context of sort of a cultural, even religious context there. But the reality is there was a similar concern in Northern Ireland. I've read about it come up in a number of different scenarios with respect about the security officials entering homes, and the potential breach of privacy, of course, is what spawned the RIPA legislation in the United Kingdom. And so I think that's one question of it from an operational perspective of where there is an expectation of the right to privacy, and there's a practical it impacts on operations eventually, right? So if you create problems in people's homes, they tend not to cooperate with you if they see it as interfering with their personal family privacy, family honor. I get back to this wording in the IHL provisions, but I question whether in a context where a state may have a CCTV scenario where you're in the public, and the question is whether you're walking around, whether you have a different expectation of privacy, such that this is just an increment farther. This is not only can I see you, and if I know you, I recognize you. This allows me a technical way of recognizing you. And then it's tied to the question of capture or targeting, whatever you're going to use it for. It seems to me that that's a distinction as to what your expectation of privacy is. And then if you carry it farther, we get into the scenario that you raised, Lee, which is of what use it's intended, right? And so a lot of the discussion I'm hearing is with respect to data collection, it's for something else other than targeting, right? It's not the immediate notion, in some ways, the immediate notion of targeting. Although what you're doing is you're relying on this data in order to, in the moment, make a decision on what you're going to do. But it's different than setting up a digital ID card for the governance in the territory you're in. And then the final comment I would be is it's important in international armed conflict as it is in non-international armed conflict because of the notion of occupation and governance. And so it seems to me there, if you're using facial recognition in order to find an insurgent who's going to attack you, is different than using facial recognition to identify a protester that doesn't like the way you're governing. You're back to this question of what you're using it for.
Well, that's interesting because it kind of goes back to what are you asking people to do, right? What are you asking people to do? What are you using the information for? And then as those kinds of things change in tandem across the operational spectrum, I think these are two good things that I need to be thinking about when I'm explaining the factors, how those factors affect that as well.
João?
So in bioethics, if I collect somebody's data, like medical exam, and that person, given our experiment, I consent to that data being used for a certain purpose. And if that data is going to be used again in the future, you would need another consent, unless it's somehow, even that is controversial, but if it's somehow directly derived from the first use, then you may get away without it. And in that case, it's probably a very simplistic solution, and there are probably reasons why this is not implemented if it's not. But okay, you got the data to protect innocent lives, and now this is encrypted here in, I don't know, some sort of lockbox. And if you wanted to use it again, you have to give me a reason. The burden of proof, it can be internal to the let's say the US or the Canadian military, but some kind of objective review. And okay, if there is going to be the drone strike that was determined necessary somewhere, and that person might happen to be there, and I will use that to help not target that person. Okay, you can use it. That's not controversial, at least if it was granted initially. And then, but if it's more complicated than that, then there needs to be some kind of review, because it seems like the burden of proof, it's still on the person who has the data. It's not just because the state has the data, it can just do whatever it wants. The burden of proof, it remains with the states to justify why you will keep that data and why you use it in the future.
Absolutely. And I think that's why I think I need to spend a bit more time in my third section talking about what I mean about thinking about privacy protections in advance. And it's that kind of specific thing, is putting policies in place for, okay, well, what other things could we potentially use this data for, is a question that would need to be asked. And who would need to consent to use this data in a non-targeting way, but for a different operational purpose. And what controls would be around, like the purging of data, all of that kind of thing that we think about in data protection schemes, but also in just privacy protection schemes. Like, I do a lot of work in privacy in Canadian law, and it's like, well, a right to privacy, may be significant, but if there's all these other secondary controls around that information, who can use it, who can see it, when they're allowed to employ it, right? Then that minimizes the potential intrusion into the right to privacy, and it makes it, it's only for necessity and proportional use, then that's okay, right? And so all of this is the type of thing that I'm saying needs to be thought about in advance, right? Not just going in like we did in Afghanistan, collecting a bunch of information, using it for all different things, and never thinking about any of these controls, because the right to privacy wasn't a factor when we were collecting this information. It wasn't considered. And so you saw mission creep with no increased controls over that information until the point where it could fall into enemy hands, right? So I think that you're absolutely right. This is part of what needs to be thought about in advance. And it's part of what makes subsequent use of that data or a facial recognition technology reasonable and proportionate in the context. Like, it's like all of these secondary questions need to be considered, I think.
Okay, so I think that concludes the discussion with a lot of further thought for how to develop that issue. I want to thank you, Leah, for a great presentation. And I want to also thank Ken Watkin for being a respondent. I think it was a very, very interesting discussion to end the third day of our workshop.